Good evening, ladies and gentlemen. It's a pleasure to welcome you to this evening's program, which will be a discussion of how to navigate the Bureau of Prisons. This is a program that is sponsored by the Federal Bar Association, as well as the Federal Practice Program, the CJA unit. As many of you know me, but for those of you who don't, my name is Randy Sue Pollock, and I'm the president of the Northern District of California's chapter for the Federal Bar Association. Before we begin, I'd like to welcome all of you who are members of the Federal Bar and encourage those of you who are not yet members to please join. The Federal Bar was established in 1920 to serve the interests and needs of the federal judiciary, the public that they serve, and federal practitioners, both public and private. Our chapter is a very busy chapter. We've been presenting 1 to 2 programs a month, and we are I have a special membership plan for U.S. attorneys as well as federal public defenders, so I hope that you all will join. As far as upcoming programs that the Federal Bar has planned, I'd like to note that May 1st we have a program here in this courtroom that's going to be a reenactment of the Vincent Chin murder case. Judge Donson and Judge Lynn will be participating in that program. May 21st will be the annual Views from the Top, which will feature Izzy Ramsey, who is here, as well as the heads of the SEC and the Antitrust. Then May 22nd will be our civics program here in this courtroom. It's going to be a special program focusing on the 70th anniversary of the Brown versus Board of Education decision. Then June 11th in San Jose, we're going to have the storytelling in IP cases. How to present complex demonstrative evidence to juries and judges. And that's going to feature Judge Freeman, Judge Kong, and Paul Graylaw, former magistrate judge. We have programs scheduled throughout the summer for young law students and young lawyers. So I hope you can attend many of these programs. Regarding CJA applications, they are due April 22nd. So note that. It's a pleasure to have this panel here today. Some of you may have attended back in 2018 when Jack Donson came out here, and I wanted to redo this program for some time now. So at this point, I'll turn the program over to Ed.
Thank you, Randy Sue. And I first of all want to give a shout out to Randy Sue for pulling this together. This is her brainchild, but so many of these recent programs have been, and you do a fabulous job. So I think round of applause for Randy Sue. So welcome to our program on navigating the Bureau of Prisons. I'm Ed Swanson, Swanson McNamara, and I'm delighted to join these folks on today's program. Let me tell you how we are going to do this today. There's a lot of material to cover. It's similar to not exactly what you got in the material that was sent, but we are going to just get started to do that, and we'll save questions for the end. So there'll be 15 minutes at the end for questions, and I'm sure you'll have some. I got some questions from some of you as well, so I will toss those in as we go. But there'll be time for questions at the end. So we've got a great group of experts in the field here, and let me just introduce them before we get started. On the left is Jack Donson, who is the Executive Director of the Federal Prison Education and Reform Alliance, which he'll tell you more about. Former BOP Correctional Treatment Specialist, who spent his life working with people incarcerated in federal prison as a consultant and an advocate. To his left is Paul GIBSON, who also spent much of his career at the Bureau of Prisons, retiring as an associate warden. And he served much of his career at the penitentiary level, has done a lot of work dealing with county issues in prison. We have Dr. DIANE Summers, who recently retired from the Bureau of Prisons as the Chief Clinical Officer for the Northeast Regional Office, where she oversaw 16 BOP facilities. And we have Don Ferdula, who recently retired from the BOP after a 25-year career, working in prisons at every level of security. She was a correctional treatment specialist, provided services to people in the BOP, and designed her own program to help people that she was working with on reentry. So we've got a great group of people here who really know their stuff, and I had the chance to talk with them getting ready for this program. I've been doing this for a long time, and I was shocked at how much I did not know about how things actually work with the BOP, and you will now learn those things. And so, I'll that.
Thanks. I'd like to thank DIANE and Randy so much for this opportunity. We really like to get out and we provide a lot of practice tips that you usually don't get when the BOP does their training. It's more of a broad presentation, and what we do, we're all field practitioners working directly with the incarcerated, and hopefully the organization we recently started, we're going to support the broader federal justice community and all the issues with some of the content you're going to hear today. So I'm going to get right into this so we can cover as much as we can and have time for the questions and answers after, as well as we'll be hanging around after as well. So, we won't be until the last person leaves unless we're kicked out of here. So I'll start with this. I kind of emphasize enough how the BOP considers the pre-sentence report their Bible when it comes to things, and like the impact that really has on a person's incarceration. Something that I'm going to start out with is really like a big ticket item is when you have the overall incident offense behavior identified in the pre-sentence report. Basically, the Bureau of Prisons scores the overall offense behavior, even if it's conduct that's not attributed to your client per se. So, for instance, there's a large drug conspiracy, there's maybe some violence in the case, you might have like a low role in that case, and basically they're going to score it with the overall offense behavior even for conduct that's not attributed to your client, which could make it like a great severity offense, result in more security points and things like that. So I can't emphasize enough how the PSR has to be accurate and just to understand the ramifications that has. And I don't know how you want to speak a little bit about in general. Okay. So, and I understand that in your district as well, like your pre-sentence reports covers that overall offense behavior regardless, right?
Yeah, so what you do, Jack, if you got a statement of the offense in the pre-sentence report that is accurate, but it is describing conduct that your client himself or herself didn't actually do, how do you make sure that when the BOP is looking at this, they don't score your client based on things they didn't do?
So obviously who knows what the statement of reasons is? The statement of reasons is basically required to be obtained by the Bureau of Prisons, and that's where you would clarify certain things. So somebody with a more minor role, which might be a 3-point offender for a drug case, is not attributed. Violence, which is a 7-point grade severity offense, that also is associated with what's referred to as a public safety factor that we're going to actually cover as we go through this presentation. And so that statement of reasons is extremely important that the court, we met with the judges earlier today, we put impress upon the judges. The judges should basically make a ruling on that and make sure that the Bureau of Prisons is not considering that overall offense behavior if it's not conduct attributed to your clients.
So can you sort of explain as a practice matter how you do that? We don't get the statement of reasons until it's done. Just that gets sent off to us at the end. How do you make sure that when the statement of reasons is put together, it contains the right information?
Well, there's a block on there where you actually clarify that. Like you would be at the sentencing, you would be discussing that, and then the clerk would be typing that on the statement of reasons, and that document would have to be accurate. It would have to clarify that. You're just making sure that it's typed in the appropriate place in the judgment. And we have a sample. There is a sample of the statement of reasons as we go along. So here's that being said, here's some important practice tips. I talked about the incident offense behavior, but actually unknown dispositions. We talked about this before quite regularly. How about unknown conduct in the other section of the pre-sentence report? The BOP scored that as detainers. If you have ambiguous dispositions in the prior record section or the other conduct, the BOP is going to score on the side caution, and they're going to be attributing detainer points to that. So that's the example of another, you don't want an ambiguous, you don't want unknown disposition. You want probation to make sure that they're putting something definitive there, that the Bureau of Prisons is, not concerned that there is something pending out there. So that is plea versus verdict. Most people plead guilty, and that's why they consider the overall offense behavior, but in the rare instances of jury verdicts, the agency can only consider the conduct associated with that particular count. So that's also.
Just make sure you get it right with that, like these are terrible mice in a room with terrible acoustics. So.
Sure. Scoring of violence.
So we're generally going to try to hold things with the edges because we have so much to cover, but go ahead, shoot, you got it, and then we'll just keep going.
Would it be helpful if the probation officer accurately describes the general offense conduct that you put in certain enough, and you suggest that she adds certain kind of true statements, but there's no evidence that defendant so knew about this. There's no evidence that defendant so-and-so was there, so maybe some of the POP discounted.
The probation officer narrative, definitely. You want this is targeted to the client, and if there's something that's going to mitigate that, absolutely. Every district is different. We're used to dealing with presents and just describe the overall case, and so yes, but absolutely. And then if it's not to your satisfaction, it should be definitely clarified in the statement of reasons. And then we talk about violence too. The Bureau of Prisons scores prior violence. There must be a finding of guilt, but for instance, sometimes you'll have a simple assault with a fine, and they will score that serious violence when it comes to the points, just because there was a finding of guilt. So, where it might not be an issue with guidelines, calculations, and things like that, just be aware that your clients are getting hit on prior violence as long as there's a finding of guilt. Based on that overall offensive behavior, I use the analogy of a simple assault with a fine, but it involved initially somebody hit somebody with a baseball bat. They're scoring that at a high level. If it happened within so many years, it could be scored 7 points alone. I mean, it's just something to be conscious of. When it comes to drug offenses, I mentioned there's a 3-point offense and there's a grade severity offense based on role. You want to make sure that the role itself, higher level roles, which are defined by the classification manual, which is 5100.8, there's actually at the back of the manual an appendix that actually goes into the various roles. So you really want to look at, it's a combination of drug weight and then what that person actually did within the organization or within the case. And so they could actually score drug offenses 3 points, or they could score 7 points.
And so how do you control for that? So it's not just the sentencing guideline or the offense points we're talking about.
Right.
It's actually analyzing the facts of the case.
Right.
So again, this is one of those where you're going to want to get in the description in the PSR and make sure that you're looking at the BOP scoring system and mapping that on your facts.
Yeah, go into it, you really just want it really defined in the pre-sentence, that actual role that person played, absolutely. And you could get points for enhancements, you do role adjustments, but it really has nothing to do with the Bureau of Prisons policy. Bureau of Prisons policy defines it by that appendix at the end of the manual as far as that goes. GED, here's the big one. We talk about the classification system, and is it the next slide, or when we talk about the point system, 0 to 11 points CAM, 12 through 15 low security, 16 through 23 medium security, 24 points plus high security. Let's talk GED. How many preset history reports do you look at that says GED pending, reached out, no verification? That's 2 points on the classification, just for not verifying the GED. A lot of the preset history reports we look at are unverified GED. When is that significant? It's when somebody scores out to be 23 points and they really could, or 24 points and they really could be in a medium SCI, which is a serious environment, but not a penitentiary environment. Our penitentiaries are very violent places, and so something as simple as not properly verifying the GED could result in a penitentiary placement unknowingly. And this is what I referenced earlier, is the statement of reason. If you look at what's circled here, that is a place where you would actually draw the distinction and clarifying what's happening in the pre-sentence report.
And so, sorry, just when it talks here about courts are encouraged to adopt procedures to ensure the statement of reasons is used to translate all findings, both guideline and non-guideline related. That, I think, that was news to me. And I think that that's something that it sounds like some districts are more advanced in than others. Is that the case?
Yeah, absolutely. I'll tell you this, New Jersey, we did training in New Jersey in December, they were blown away by just the overall offense behavior was attributed to their clients, because every pre-sentence report they do has everything in there. And so they were really like, the judges were like, couldn't believe that, that is the case. And so they made an effort in, their district, that they're from now on going to be clarifying anything that was blocked and circled there and stated the reasons. We're going to talk about 3 different things with classification as well. I mentioned the point system. Has anybody ever heard of public safety factors? Raise your hand if you have. I'm just kind of curious. So besides that point system, which is just raw security point scoring that we'll get into a little bit, there's other things that can enhance a designation, a security level, basically. And so we're going to be talking about that. Has anybody ever heard of a management variable? So just see. So besides points and besides public safety factors, we talked with the judges today about management variables. A public safety factor, we'll roll on here. All right, so I'm going to go back to the points, not rotating points here. So how many know about the point system at least? Okay, so everybody pretty much understands that. And the instant offense severity is the crime itself. Bank robbery, some kind of violent crime, 7 points. That's a very severity offense. We scored up to 7 points on the classification. Criminal history score 0 to 10 points, depending on somebody with only criminal history. They get up to 10 points on the criminal history. Violence, we talked about a little bit as well. A serious act of violence in a prior within 5 years is to be up to 7 points. Escapes could be failure to appear, could be violations, technical violations of supervised release, failure to appear type of things could be scored as escape, believe it or not. And then detainers, those unknown dispositions, those ambiguous dispositions could be scored up to 7 points as well. So they're a little bit of other big items of points.
Yeah.
Voluntary surrender. What's different with a person with voluntary surrender? Does anybody know that? -3. People who are allowed to surrender to the marshals or designated institution for the service of the sentence start out with a -3.
And you also say on the previous slide, I think, that people with detainers can be housed in the camp. Tell us about that.
Yeah, that is true. I mean, the Bureau of Prisons, I ran a camp back in the 90s, and up to this day, you can be in a federal prison camp and have a detainer, because it's simply the scoring mechanism. If they're not up to 11 points, that could be detainer points as well. You could be housed in the camp. That people don't have a lot of people think you can, but you can't. These are the big ticket items. This is what the classification worksheet looks like in the areas we were just talking about, the -3, the instant offense severity, the violence, everything that's circled here are kind of those big ticket items, the GED. You can go and the BOP website, bop.gov, and sit there, and this is the BP 337 form, and you can sit there and put the data in there and hit enter, and itself totals, because One thing to be aware of, we hear a lot of times judicial recommendations, they're picking facilities, but you really can't pick a facility until you really know the classification. You can't just assume somebody's a minimum, medium, low, until you really have some basis of scoring. And then that, when we broke down this, we talked about this is what it looks like. Male and female actually is different. Why? When they updated the manual in 06, they came up with different scoring systems for males and females, which is interesting. Administrative facilities, we told the judges today, be careful when you wish for the closest facility, because the closest facility might be a work cadre, which is a high security administrative environment, and you could have a minimum security white collar person, and the closest place could actually be somebody serving their time in the designated work cadre.
Can you explain a little about what that is and what administrative facilities are?
Administrative facilities, your MCCs, your FDCs, your just administrative pretrial and older facilities, medical centers, they're considered administrative facilities technically, but they have an administrative mission. The most common one here, like here would be Los Angeles, you would have your facility would have a small work cadre. They are minimum low security level people serving time there, but it would be white collar, close to home, and end up there. It's cook, chill feeding, it's high-rise living, it's not a pleasant security environment for anybody to be serving time in.
And it was work cadre. It sounds like a gulag.
It's referred to as a work cadre. They need people that can get gate passes to work outside the fence, and they just want that mellower type of environment to work on facility jobs. That's really on that. The public safety factors. Now these are interesting because aside from the point system, the public safety factors can enhance the security level. And so, Paul, you want to talk a little bit about disruptive group?
Sure. So, Jack, the public safety factors are going to increase the inmates' defense security level. Mostly, honestly, all these will keep them out of the administrative facility, regardless of what their offense is. Speaking specifically about disruptive groups, there's 6 gangs that the government identified that will only be housed in a high security facility. So no matter what their offense is, no matter how many points they have, if you're a member of one of those 6 gangs, you will only be housed forever in a high security facility. That can be waived, but it's very, very rare. The 6 gangs are Mexican Mafia, Mexican Texas Infantry, Caring Brotherhood, La Noche Familia, and Soldiers of Any Color.
So, you talk about and you need to get really close to the mic. It's just really hard for folks to hear. Can you talk about waiving public safety factors? Is that something that we can ask the court to do, or is that something that is entirely up to the BOP?
My opinion is some judges go outside the box and recommend the public safety factor be waived. And we'll talk about different ones, but actually, a sex offender public safety factor precludes camp placement. And so a CP person, child pornography person, that has in the community complying with bond, they surrender to a facility, they're going behind a fence. They go behind a fence, they get checked out, they refer to that as a guy showing your papers. They end up in a vicious cycle of protective custody a lot of time. I mean, an example would be, you can waive that public safety factor for camp placement. The agency will not do that on their own. And it's non-binding if the judge recommends it, but I mean, that would be an example. Another example that they do periodically waive is the greatest severity offense. I've seen greatest severity offense public safety factors waived so that they could provide for a lesser security placement. Some of these other ones, not as common. Alien's an interesting one. We talked today with the judges about the alien public safety factor in the manual. Non-citizens, whether you came over the border yesterday or whether you're a permanent, legal, resident alien, you get the same public safety factor, and you cannot be designated to a federal prison camp. So that's to me another appropriate use of the waiver, but unless you're going to get a judge to recommend it, it's probably not going to be considered by the Bureau of Prisons.
But is it, based on your own experience, is it something that the Bureau would actually look at if a court were to recommend a waiver of a public safety factor, say it's a CP case or great severity? Is it worth asking, or is it just a waste of words?
It's definitely worth asking. They're definitely going to look at it. And every case is different, obviously, but they're not going to do it on their own.
And I would have to say that it has to start somewhere.
You want to get,
Sorry. I would say that it would have to start somewhere, so if judges would start recommending these waivers, then the BOP may start taking more of an active role in placing offenders in situations outside the box that they wouldn't normally consider. So someone, that may not, a legal permanent resident may not typically be designated to a camp, but now you have a judge that is actually aware, and you have defenders and assistant, prosecutors that are actually aware of how the situation works and are actually asking the BOP to take a look at this. Those things are going to be considered more frequently.
And let's take a look at the sentence length public safety factor. There's 3 sentences on the public safety factors: greater than 10, greater than 20, greater than 30 years to be served. So somebody served, if you know what you call a person with no criminal history sentenced, and they have the sentence requires them to serve over 30 years, they're designated to a penitentiary. And so that's another, like, would be an example. We have seen those ways sometimes, but again, I feel that you should be advocating for things like that. Greater than 20 years, you must be housed in a medium security facility. Greater than 10 years, you must be housed in at least a low security facility. So that, that's just another example. They're the most common ones, actually. And then just to be aware, it's a point system in combination of public safety factors, which are the driving factors of classification. The next one I really want to talk about, which I consider is like more profound stuff when we talk about management variables. And then we talk, management variable can bring a person below or above the scored security level. And I'm always using the example of the young person, 24 years and less. They have 8 security points if you're 24 years or less. And so how would you like a typical example of like a young person in the point system?
So I should think about a defendant who is 22 years old. He's getting 8 points off the bat just for being young. So he's got a role in the offense, there's violence in the offense, he's getting 7 points for that. So there's 15 right there, for just 2 of the categories. Maybe he's got some prior criminal history. He's getting 5 points for prior criminal history. We're at 20 points there just on 3 categories. Most of his points came from his age. If we keep adding this up, we may want to do a penitentiary as far as points are concerned. But most of those coming from the age category. If you could request that the judge do a lesser security mandatory criminal as a judicial recommendation to a medium, thus avoiding a penitentiary status for a youthful offender who is going to be, he'll have a hard time with penitentiary. Think about it, penitentiary's main goal is safety and security. It is for real. If you have never visited one or worked in one, it's a rough place. It's 14 years of penitentiary. It's much higher staff. The staff to inmate ratio is much higher penitentiary. Programs are fewer because the focus is on security. In my 14 years, I was involved in 4 inmate homicides and 1 staff homicide. So it's a real environment.
What do you know about the penitentiary there, right? When someone 23 years old.
2 things they're going to do. They're going to join a group. If they're not part of a gang, they're going to join a group just because they're looking for someone to watch their back. 2, they're probably going to carry weapons. It's equalizing.
So can you talk then about if you got this person you're talking about, young person scoring all the way up into penitentiary, what is the ask to the court? What do you
Ask is to assign a lesser security management variable. I do agree that waiving the public safety factor sounds more like, I guess, it sounds like maybe more difficult of an ask, but it's not a difficult ask to request that a young person be put in a media environment on a lesser security management variable. And this is the bigger point too, because this really sells itself with the court. The definition of a lesser security management variable, as you see, we have it highlighted. The Bureau of Prison's own classification manual says, for example, when age is largely the contributing factor in the inmate's placement, this management variable will apply. And so it's like, it's the OPOP policy almost saying like, you should use this in this situation. But the agency, in my opinion, is not really looking at this policy and maximizing this policy in the benefit of your clients. And but with the judge would be outside the box, they would look at it, they have to look at it. They attempt to accommodate judicial recommendations. I mean, so it's just a practical use of their own policy, to be honest with you. And so, it's a big issue with young people in penitentiaries. Go back to some of the other barriers, like.
And just before we leave that, just trying to think of what we actually do when we're in court. We are asking the court not just to say medium security placement, but management variable, like that. Those are the words that we would want to have.
Absolutely.
In the statement of reasons.
That would be in the verbiage of the judicial recommendation itself in the sentencing order. Exactly. That's what that would be. And you see, there's one thing, believe it or not, this is somebody, but there's actually a management variable called judicial recommendation. Seriously, like, they're doing it, they're justifying it based on judicial recommendation alone. Never mind lesser security, and actually, when they waive a public safety factor, the management variable is PSF waived. I mean, these are all policy-driven things that are just be aware of them. So when you do advocate it, I mean, some judges go farther than others. I've been in court where a judge will say, I don't make recommendations. And some judges will actually take the verbiage that I have to do the declaration word for word from the clerk and put it in there. Doesn't really mean they're going to do it, but if they're at least going to look at it, and to me, if you're selling it the proper way, and I always use the profound example of the juvenile, it's just the right thing to do. That's the problem.
What would you like to see happen with your young offender down the line is that he doesn't reoffend. And if they're sitting in a penitentiary where you're locked down because something happened totally unrelated to your client and the person's not involved, they'll lock the entire institution down when they do an investigation, well now he can't go to education. He can't work on his GED. He can't work on his programs that he's supposed to be programming so that when he does get out, he has a better future and potential not to come back. So especially with the younger offenders who a lot of them don't have a high school education, don't have a vocational skill, to try to get that management variable and try to keep them out of those penitentiaries.
Dr. You're talking really into your medical and psychological care, so.
Okay. Medical in terms of scoring points has no real bearing on that. It does have a bearing on designations when the Bureau implemented its 4 care level system. So the care level of your client does come into play where the PSR, not so much for healthcare in the Bureau, but prior to being designated, anybody that has significant medical conditions listed in their PSR will be referred to the Office of Medical Designations for review of what is available records. So if we don't have a whole lot available, they may not get placed in the correct place the first time they're designated. In an ideal perfect world, we'd like to see everybody go to the correct place the first time. Our care level ones, it was all based on what was available within the local community surrounding institutions. So our care level 1 facilities are for generally healthy people, well-managed medical problems, and are usually located in our remoter parts of the United States, where healthcare is very limited. Hospitals are much smaller.
Care level 2s are in around bigger hospitals, may not have a tertiary care center or, university type, but they have a community hospital and they have enough specialists in that area pretty much to generally take care of most things. Care level 3s are usually located around larger hospitals, more subspecialty care. And our care level 4s, which are considered medical centers, kind of gets people confused because all of them have an association with a very large tertiary care center like Rochester, works with the Mayo Clinic. FMC Butner in North Carolina works with Duke. Our medical center in Massachusetts works with the University of Massachusetts. They have very close working relationships with university-type hospitals, tertiary care type hospitals. What they can do actually within the medical center is actually limit beds. And when you think about a hospital and you think about people being in a hospital bed, FMC Devens in Massachusetts only has 14 inpatient beds. But they do run our dialysis unit, they do run our transplant unit for solid organs, primarily liver and kidney. So all of our medical centers have over time taken on some specialized roles. Butner does most of our cancer, but FMC Lexington in Kentucky does all of our leukemias and that type of stuff. So knowing also that things change while you're in trial and things occur over time, and something occurs between the time the PSR is written and they are going sentencing, it's really important to let the judge know so that they can, that also can be included, or that can get to the Office of Medical Designations to try to get the person to the right facility. Once they get to the facility and we do our screening, we'll do our best to try to get them if they are placed in the wrong designated facility. So sometimes while you're waiting for a designation and you're wondering, why is this taking a little bit longer than it should? It may be that OMDT is looking at trying to find the best place to put the person, trying to keep them closer to home, away from the separate. I give them a lot of credit because they juggle a lot of balls of trying to get people to the right places at the right time. Going back to the pre-sentence report, I've seen a lot of, and this has happened mostly because of our start of our treatment of opioid use disorder, that we never really look at the pre-sentence report once the person's designated at the facility. We go on, we see the patient, we treat them, and we move on. But now to verify their substance abuse disorders, we're going back to the pre-sentence report. So you have some people who didn't tell anything in the pre-sentence reports that ought to be held against them. So they said, I didn't have any problems, I didn't use any drugs, I never did any of this. We're just going to come back to bite them if they go getting along the way and say, you know what, I really have a problem with opioid use, and I really want to be treated, and now you're going back to them saying they never had a problem. So try to get them to be as honest and let them know that what they put in there under the pre-sentence report and medical and psychology won't be held against them. It's going to be used to help them down the line in the future, as opposed to trying to hide their drug substance abuse. Which then when we go to try to verify their substance abuse history, that's not there.
Let me clarify a couple of things from a case management perspective, because obviously doctors clinical, we're case management background. And so one thing she had mentioned is the Office of Medical Designations and Transportation is in the VA or MDT. So that's important. People using these acronyms. They're the ones who will process the medical designation. So just be aware in that process, they're getting their information from the pre-sentence reports. And so what you really want in there is current medical condition, diagnosis, medication, and dosage unit for that particular medication. What we usually see in pre-sentence report is a hodgepodge of medications, self-reported diagnoses from childhood, and it's very difficult for you to ascertain things for the designation process. If you want to speak on that at all.
Yeah, sometimes when I've seen some pre-sentence reports go all the way back to, when they were 4 years old and they had their tonsils taken out. And, so really more current, the last 1 to 2 years of treatment is the most important, and an accurate and current medical list. And if you do have somebody that does have complex medical problems, I'd encourage them to make sure that they show up at the institution with a current medication list. Be handwritten, it could be from their pharmacy, the pharmacy will give them a list very easily. Do not bring their medications, because we're going to give them right back to whoever dropped them off, because we can't take their medications. So I'll go on to that. We do have a formulary. It gets updated twice a year. By now, the one Jack for the 2022 winter, the 23 summer one should be in there at least. So that you can access that to see what's on the formulary. We do our best to try to, if they come in on a drug that's not, that if they're on that, is different from what we have, we can try to make a therapeutic substitution. Every insurance company in the United States has a formulary. If you ever go into the pharmacy and they say, we don't have your medication ready, we have to call your doctor's office because we have to tell them what your insurance company covers. And, they have to get a substitution from the doctor. We do exactly the same thing. However, there are times where there is only one drug on the market and only one drug on the market for something. And we will do our best, and usually do, continue that medication.
So can I just ask, on the formulary, is that something that we can look at so that we can see if BOP is providing what our clients are currently getting?
Right.
Where do you do that?
BOP.gov. The BOP is a wonderful website. If you drill down into these links, and the slide actually will run how our functional links when we send out the final presentation to everybody. If you click on the links to find the medical policies, they actually have clinical treatment guides as well that are really interesting. And the formulary on there now is exactly the 22 winter formulary. Part 2 is an alphabetical list. What we tell clients who are fortunate enough to be able to surrender is that you really want your physician looking at the formulary and making a substitution before you surrender to make sure there's efficacy with your medication regimen. Because the last thing you want is somebody surrendering, substituted, and all of a sudden it doesn't work. And so, that's like a good practice tip to have. Be aware the formulary exists and making sure that the medication dosage and diagnosis are in the percentage report.
And can we go back, Doctor, just to what's in the pre-sentence report about someone's current medical condition? Obviously, it needs to be verified, not self-reported. But can you provide any more guidance for what it is that we need to make sure is in the PSR so that when BOP is trying to designate this person, they're going to trust it and they're going to make the right decision?
The accurate diagnoses, accurate medication list, I've seen PSRs actually put the doctor's name and address in there. That is more for the Office of Medical Designations to help them try to designate them to the correct care level facility. They said once they get to an institution, we rely on the history they give us at the time that they show up, and whatever medication they say that they're on at the time when they show up. Because they, if the PSR was written 6 months ago and they went to the doctor in between, things can change. So they said, generally speaking, medical does not look at the pre-sentence report when the inmate first arrives. We rely on their narrative history. However, now with the opioid use disorder, we need to go back and verify historically. Then we're looking at them more and more. Sometimes we will go and look, someone will say, this wasn't my PSR, I don't remember the specifics or something, and we'll go back and look at it. But for the Office of Medical Designations, let's say, for some reason, and this is the only way I can think that something like this would happen, and it has happened, is somebody is on dialysis and they show up at a mainstream institution. Is that somebody did not put that in the pre-sentence report because if OMPT saw the word dialysis, they would have either gone to FMC, Devon's in Massachusetts, or FMC Bonner, automatically. So, big medical conditions. A lot of people think like cardiac conditions should put them in a medical center or even care level 3. The Bureau's opinion on that is that if you are going to have an acute heart attack, we're going to send you to an emergency room. Doesn't matter if the emergency room is in Boston, Middletown, New York, Allenwood, Lewisburg, Pennsylvania. Anybody have an heart attack is going to go to the emergency room. And so what we don't want to see though is up in, like on the Canadian border, we don't want to have somebody who's 72 years old with no heart disease. We want them at our care level 2s that are going to be where we can get them to a, you know, an emergency room in 15 to 20 minutes from the institution.
Can I ask you a question on something that sometimes comes up before sentencing? You've got a client who has a medical procedure that they need to undertake. It's going to take a little time to get it done. We are in sentencing. Self-surrender is supposed to be in 45, 60 days. This is going to take about 3 months to get the procedure done. What would you say to that person, and what should we be saying to the court?
It's going to depend on the severity of what it is they need to have done. If we're talking about something that could potentially be life-threatening, limb-threatening, vision-threatening, then we should delay their coming to prison. If it's something like repairing a torn disc that's going to need, whether or not to do it now or do it in 6 months from now, is really not going to make any long-term change. So, and we also get a lot of these people who are midway through something. When I was Northeast Region Medical Director and acting behind us, I always wanted them to finish their course of therapy before they came in, because I didn't want to see them have a delay in care or a disruption in care. Yes, I can get something picked back up. The first person has to get designated. Then they have to get to the institution. Then they have to, you know, see medical. And then we have to call, make the appointment. And if anybody's ever tried to make an appointment, you'll get, okay, we can see them in a month. And then they go out, and, you know, so I always want them to try to finish whatever they started before they come in. I don't always win that.
And I think one of the things you brought up when we were talking before this panel today is that if you've been through a course of treatment with a doctor and their recommendation is you get a certain operation, if you get to the Bureau of Prisons without that operation, they're not going to just take out any other doctor.
Right, because again, we would have to reschedule them and start all over again, so it also depends on where they were in the process. And a lot of work, like especially orthopedists, are very, very, very picky about who does their MRI, when the MRI is done. And you also, because none of us do everything exactly the same as everybody else, you could have somebody say, I don't really need that. And that then creates a even bigger problem, because wait, when my doctor said I did, now you're saying you don't. And, you know, so it is better in the long run to try to get as much done before.
The bigger point on that was, if you look at the slide that's talking about outpatient care, if you had to learn one medical policy to refer to what would be patient care, because it talks about emergent care, non-emergent care, the utilization review committee of the facility, and he makes these determinations on is this elective, not elective. And so just because you have the schedule in the community, they're going to apply the patient care standards to the care once the person's there. So I strongly suggest that the BOP medical policies you see on this slide, you're aware of these policies. These are medical policies.
A little outdated, being updated, but, you know, DIANE clinical direction in the Bureau of Prisons is a juggling act, especially if you're in penitentiary. When they take say you can't take your trip out that day because we need the officers to do this, you have to make the decision between the guy who has shoulder pain or the guy who has severe heart disease, who goes out and who gets rescheduled, because security, not only security of the institution, but security in the community is paramount.
One question that comes up a fair bit is we'll get contacted by our clients who are in custody, who are having trouble getting the medical care that they need. What's the best way for us to advocate? Who do we contact? How does that work?
It also depends, it depends on how far, you should ask them, what have you done? What have you talked to? Have you gone to sick call? Have you been seen recently, if they have chronic medical conditions? They'll be followed in chronic care plan. Have you talked to or written a cop-out to your primary provider? Everybody has a primary provider. It is a mid-level provider. It's a nurse practitioner or physician assistant, because you have, let's say, we had 1,700 inmates in penitentiary. Supposed to have 2 doctors. I was by myself. But I have 3 mid-level providers. So the 1,700 were divided among those 3. I actually have 3 phenomenal mid-level providers who are very, very attentive. So they're their first line of defense. That is their primary provider, and that's who they should go to. So you should ask them, did you go to sick call? Did you try to contact them? If they say, well, yeah, and they blew me off, then say, have you talked to the administrator over medical, or have you talked to the associate warden over medical? And usually at that point, most things will get addressed. Before they start, writing all the remedies and all of those things, is go to mainline, talk to the associate warden over medical.
What is mainline?
I'm going to turn that over to Paul because he was the associate warden.
So
Where's your term mainline?
So the warden, both associate wardens and captain, the administration will stand the noon meal every day. They're there to address concerns. So if someone's getting blown off by this person or that person, they can walk up and talk to the warden, the associate wardens, freely, no issues, and have their concerns addressed. If you have a really good department head, which I have a couple really good ones, I didn't get a lot of questions because they handle their business. But at least it's a little bit different. So ask your client, did you go to mainline talk to the place that?
And then let's just say we've done all of that, and they said, I did it. Who do we contact? How do we do it?
Well, that's when they start the administrative review process.
Yeah, let me address that too, because a lot of times your clients don't understand the chain of command and who to go to and what role plays in the facility. So does anybody know the difference between a counselor and a case manager? Anybody? Want to take a stab at it? There's got to be somebody. Go ahead.
You mean go down to the institution and seek that person out?
No, I'm talking about people in prison are go through orientation, which explains to them how to resolve issues. So Ed's talking about, when you really can't get relief, you have to make sure that your clients understand there's a chain of command and there's a specialization of positions. A counselor is a glorified correction officer that have professional governance theories that don't require an education. And so, like a lot of people say, oh yeah, I have to be a counselor. Well, talk to the case manager, the more technical person, and then if you go to the unit manager, and like Paul described the main line, there's a pecking order, which is the unit team, the unit manager, the associate warden, and then the warden. And you really want to try to resolve things internally as best you can, making sure that they're doing the right thing. Because once people start reaching in that really, the Bureau of Prisons puts up that barrier. They really don't like outside inquiries. It's just a fact. And that's like a last resort. The inmates have access to what's called the administrative remedy process if they're not satisfied with that chain of command, trying to inform something informally. And then if you have to, really reach out to anybody, I like to tell attorneys sometimes cultivate a relationship with another attorney, whether it's in the consolidated legal center or the institution, the regional office, the regional counsel, or the central office counsel. Same kind of concept about going up the chain of command. Now, an attorney's not really over the facility per se in the CLC or in the region, but sometimes it's to start that dialogue, get in contact, maybe they have a suggestion for you. But,
Regional counsel will reach out to the regional medical director. If you reach out to the regional counsel, they almost always reach out to the regional medical director and say, can you take a look at this for me? And all the regional medical directors in each region have access to every one of their institutions within their region to take a look at the electronic medical record and can at least provide you with an answer, or if not, resolve your problem.
we're going to move along, but the last thing on this particular slide is important. When I mentioned those policies on the last slide, the regular Bureau of Prisons program statements, there's like 50 additional clinical treatment guides actually that you could access, and the care levels. Did anybody ever hear of a care level before they came in here today? Everybody has a physical and mental health care level 1 through 4. So then it is defined in the clinical guide, even though there's policy language on care level classifications. one of those 50 guides, that's a non-policy document, actually describes the care levels and the care level criteria. So it's just important you're aware that these things are out there as well.
And Doc, I don't know if you want to get into any more specialization of facilities with the designations on this next slide.
No, I don't think so. Just to bear in mind that if your client does need to go to a medical center, you most likely will not be near home because of the specialized admissions, and also the fact that there's usually only one per region. The females only have one, and that's Carswell in Texas. So we do try to sometimes, even though in Carswell is a 3 and a 4, we will often try to push some females that are 3s, kind of 2.5 maybe, 2.75 into care level 2 so that they can stay closer to home, so that they can visit with their children. Most of the care level 2 female facilities are within very good medical care. So if you do a care level 3 female, we may actually lean towards putting them in the care level 2, especially with the shorter sentences, so that they can be closer to their family, which is very important for support and also seeing the children. So we have to weigh those sometimes and kind of do a balancing act there.
Sometimes the mitigation we get in the Northeast is that if the person female has medical conditions, it's going to be an administrative environment. So you have a white-collar person who's never spent a day in jail, has a potential medical designation. That's Carswell, Texas, so far from the family, an administrative environment, which is a higher security environment. The courts need to be aware that that's a potential that the person's going to be so far from home in such a more secure environment, because everybody always has a false assumption, white-collar, go to a camp. Maybe not necessary, it might be administrative high security facility in Texas. So that's important to know. And then, Doc, can you talk a little about Beamer? That's important. And then, have you ever heard of the terminology Beamer? Doc?
That's our acronym for the Bureau of Electronic Medical Record. Yeah. Which just recently, I can't really think how many years ago, used to be total psychology, a totally separate system. They finally integrated them into the electronic medical record, so they can now see medical, and we can now see psychology. There's still some stuff that's blocked from us from psychology, and that's fine. For the majority of the time, we can see the important stuff within psychology, because before the two systems didn't talk to each other.
PDS, right? PDS.
PDS was the old system, and now they have their own section within the electronic medical record.
Have people heard of the PDS psychology data system? The formats and fonts are pretty much the same that it used to be, but now it's within Beamer. When you're doing your compassionate release work, you're obviously seeing medical records, or your Beamer records. But you also notice a different kind of font format. It's the PDS psychology data system records. It's important that you get PDS records for various reasons, because there's psychology services staff and clinical treatment notes. So sometimes, has anybody ever heard of the Challenge program, a residential therapeutic community program at a penitentiary for people with either drug addiction or a psych diagnosis? But there will be sometimes favorable clinical treatment notes in PDS records, which really should be accentuated, especially like compassionate release motions and things like that.
Okay, we've got about 15 minutes before questions, and I know that one of the things that people are going to want to know an answer to is the next question you got, which is, does the BOP follow judicial recommendations? What's the answer to that?
The BOP, by policy, attempts to follow judicial recommendations. They've historically tracked it at 70%. I've never heard a lower percentage than 70%. We've shown the judges today, like in the computer system, when a designator is sitting down at the computer to do a classification, there's a field in the computer for judicial recommendation, yes or no, for a program and facility. And this is all put right in the system. And then if they comply or not comply, there's computer remarks. So absolutely, the issue becomes, is the recommendation commensurate with the classification and the program needs. So when you're just picking a facility or your client hears about a facility, it's really not appropriate to target one particular facility without knowing the classification and program needs. If you're comfortable, you can be more targeted. The Bureau of Prisons policy, when they do their training, they want general, generic recommendations because they understand that. And sometimes, many times, we see recommendations that are never going to happen just by virtue of that. It's not the classification of the person. That's why hopefully having a manual talking about understanding the point system, you kind of develop a sense of, well, you can't go there, or you kind of have somewhat of an idea of what the classification is going to be. So
I would say that do not waste your judicial recommendation on seeing a federal medical center. Because no matter what, that's going to go to the Office of Medical Designations to determine. So, you know, if you got, you know, the judges, don't put that in as a recommendation, because it's just not going to happen, because even when I transfer an inmate, I tell them, do not know where you are going to wind up when I do this paperwork. I can tell you that probably here, maybe here, some of them are like, well, can I go to Butner because I can be closer to my family? And I'm like, well, what you have, you don't want to go to Butner. That's where we do all our cancer. It is a very kind of very depressing date, because one day your friend was there, and the next day your friend may pass away. But that's where their family is. So I can't guarantee you that you're going to go to Butner. So I would just not even have that as a judicial recommendation.
RDAP, same thing. RDAP, we're looking at RDAP. RDAP, in my opinion, is a wasted recommendation. That's assessed automatically. When a judge recommends RDAP, the only thing the Bureau of Prisons really has to do is they're required to do the basic drug education program, which is not a treatment program. It's within that drug education program that they're going to assess people, notify them of the other programs, the non-residential program, the residential program, and then they're going to do a clinical interview if they meet the criteria in the pre-sentence report. So I look at the RDAP as also not really a practical judicial recommendation, because that's really automatic.
And from the case management standpoint, when an individual, when a person comes in, their case manager is automatically assessing their drug education need. So they're automatically going to put them on a waiting list. If they have any sort of drug history, they're going to put them on the waiting list for that drug education program. And then where they're going to be assessed within 5 years of release for the residential drug abuse program.
The slide up there now, as you see, historically the Bureau of Prisons has responded to judicial recommendations in writing, whether they complied or not. Way back when I was a new case manager, we had to write a letter to judges whether we complied or not. They eventually removed it for only responding to non-compliance. And then in 2007, they stopped complying altogether, but they did put out at the time, which is this memo, that if the court wants a written response, they just need to request it. So I tell judges that if you're really, adamant about a designation recommendation, I'd like to see an additional line in there. If the BOP does not comply with the judicial recommendation, the court would like a written response. And I look at it like this: the designator's at the computer, they can push a button and comply, or they can write a letter. What are they going to do? Give them kind of least resistance. Now, there's other reasons why they can't, obviously, and we talk about it's not the right classification. We have separation issues, which we can do, classes on this subject alone. But just be aware that they do have to accommodate. And I say if they can, they should give you a written response to why they did not.
How about recommendation of close to family? Is that wasted words?
No, not really. Well, they attempt to designate within 500 miles, and that was the first step I can send them to work. You can even be within 500 miles and move closer. You have to be careful close to family because you run into the situation I said with the work cadres and things like that. So I always say a non-administrative facility as close to home as possible. And that's broad enough to hit all the classifications, but the language of a non-administrative facility would alleviate the need for a work cadre type designations into the more secure environments. Positive talk about some bad things right now.
I mentioned earlier, there are 6 subject groups within the Bureau of Prisons. Now, those 6 are only going to be housed in active facilities. Those 6 groups don't all get along with each other. In fact, they have kill and sight orders for the other groups. Which means the Bureau has now identified every penitentiary specific to those types of groups. Those groups are identified as California gangs and Texas gangs. Mexican Mafia and Aaron Barlow are considered California gangs. Texas Syndicate, Alicia Familia, and Mexican are Texas-based gangs. Those groups will either be housed in a Texas facility or a California facility. Doesn't mean they're in California, it means they're in Texas. That's how they're going to be identified. So if you have a client that's one of those groups, guaranteed they're going to go to one of those facilities that may not be close to home, only because that's where that facility is. Now, complicating that further is that they also have subgroups. Sureños are a subgroup of Mexican Mafia, Norteños are a subgroup of Black from Illinois. Those groups, if they score on top security, will only be housed in either California yard or a Texas yard. Aaron Barlow in Texas, as odd as it is, does not go on with Aaron Barlow. They will only be housed in a Texas yard, or Aaron Barlow will be housed in a California yard. Check me so far? What I'll do is, afterwards, we're all, as long as you just, I can get into some more details, I don't want to bore you all with that, but there are so many nuanced gang issues, and it can impact designation quite a bit.
Well, I think we also like to hear a little bit about the behavioral programs that are available in prison. We know about RDAP, we know some about what the First Step Act is provided, but I think it'd be helpful to know what's available to our clients.
I mean, like, I'll talk about mental health programs because I worked at a secure mental health unit and they're changing the Alamo complex to a total mental health facility. But on the BOP website, you can access all the programs. And like you said, everybody's RDAP. Well, RDAP is the therapeutic residential community. It's not the only residential therapeutic community setting that's out there at the BOP. They have challenge, they have brave, they have skills, they have, they're different programs. The criteria is there, the facility is there. So if you look at the BOP website, it's the First Step Back National Programs Guide. It has all the programs in the country, including vocational programs, where you're located, eligibility criteria, and there are all kinds of residential therapeutic community type programs. And then I'll talk a little bit about Challenge, which is a really good program, and then maybe the secure mental health unit.
So we're talking about the secure mental health unit. Back in 2010, there was a class action lawsuit brought about by the inmates in the Supermax. The Supermax facilities in Florence, Colorado. And as a settlement to that class action, the Bureau agreed to open 2 secure mental health programs. One is in USP Atlanta, one is at USP Alamo. I was at the Alamo program for 3 years before I retired. It is for violently, mentally ill offenders who would otherwise go to the Supermax facility, Florence, Colorado, except for the fact that they're mentally ill. It is an outstanding program. The program has done so well, they're actually turning the entire yard at Elmwood into a mental health yard. They've expanded it from one program to a step down from that program called the Transitional Care Unit. They now expanded it to a 3rd unit, which is they're going to call the Secure Administrative Unit. That unit is basically a special housing unit for mentally ill offenders, heavily staffed by psychology staff. These are offenders that are waiting for placement into that program because those programs are in such high demand, beds are not always available. They're converting another unit into a secure skills program, which are inmates with intellectual deficits, and they're opening another program, secure stages, which are inmates who are borderline personality disorder. They are high, those inmates, 128-bed unit is being converted to an 18-bed unit because they are so intense, staff intensive. And it's heavily staffed. Each of those programs are heavily staffed with psychology and correctional services. And I was over both departments because both those departments have to work so closely together to keep the units running and to keep them safe. Outstanding programs. So if you have someone with a serious mental illness, I'm talking uncontrolled, those programs are outstanding.
And the clinicians are right in the units. We talk about the residential setting. The psychologist offices are right within the housing units. And on this slide, when you see that BRAVE program, this is like the perfect program for a judge to say, I recommend a lesser security management variable for the BRAVE program, because BRAVE was designed for young males doing their first period of federal incarceration. At one point, the BRAVE program did have an age cutoff. I don't know, it was like late 20s, maybe 28. The last time they updated the program's catalog, they removed the age. So now, the way I look at that, they intentionally removed the age limitation. So if you have a young male that's doing the first period of federal incarceration, they could have a long history of state incarceration. It's just a practical place to put this male in a medium environment to do it, to be in a residential unit in the BRAVE program. And then the last thing in the residential units, aside from having more clinicians and staffing and programming, they also have like more rules and regulations in the therapeutic community. They literally do have to walk a finer line in those units or they can be expelled from the program. So I don't know, it's
Alan just opened a BRAVE program in their meeting security facility as well.
and then basically, I'd have to start that. But the sex offender treatment is interesting. Safety in numbers. We always talk about every region has what's called a SOMMER facility, sex offender management program, one in each region. And so if you have working with a CP person or any sex offender, it's safety in numbers, especially if they have limited institution experience. They don't really have to participate in the program, but because there are so many sex offenders on that particular yard, it's a safer environment to put a sex offender in a SOMMER facility. And some facilities are defined again on the BOP website if they're in this program's catalog. And so, sometimes it is just the safety in numbers concept.
And in all these programs, just like you mentioned, RNAP is not a worthwhile recommendation because it will happen anyway. But some of these, particularly BRAVE, might be something we would actually want to call out.
Absolutely. In a perfect world, the agency is supposed to be constantly assessing pre-sentence reports to place people in these programs. So let me say that first. However, they have constraints. They have constraints on racial balances, population, quotas, so to be honest with you, they have other things working against that. And that judicial recommendation is so important to kind of get them to at least look at it, and if they don't comply, they don't comply. But I just feel it's important to be aware of what the programs are. If you're finding these new programs, sometimes when I do declarations for initial sentencing, I literally do wording what I would like to see as the verbiage for a judicial recommendation.
Okay. Let's open it up to questions on any of this or anything else.
Well, I have a couple questions about the PSR. So, given that the BOP considers all the offense conduct, what about acquitted conduct? Because the PSRs still include acquitted conduct, and so if they're limited, so how does that affect it if the client was convicted of, say a RICO offense, but wasn't convicted of murder? How is the BOP going to deal with that?
They're going to deal with it by the statement of reasons, stipulating what the actual behavior was of the client.
So in other words, it has to be the statement of reasons, even if the client was acquitted. Okay.
Yeah, absolutely, yes.
And then the other thing, to make a note of this.
So you say acquitted conduct too, you're talking a plea agreement, they'll still do and everything, correct?
Right, no, I'm talking about a jury verdict.
Well, that's different. A jury verdict is going to have a particular counts. The agency is only able to attribute the behavior on a particular counts of conviction. But as I mentioned previously, because it's so rare people go on the trial, in my opinion, in my experience, I see them use that same standard of overall instant offense behavior, even for acquitted conduct, because it's just what they do. It's like, processing volume designations, and so that's something to keep an eye on when you
We're
could.
only going to come up with the context of a jury verdict, because if somebody pleads, there's no.
Right.
But, okay, so then the other thing is the public safety factor for drug weight and role. Now I think I understand what my client's complaining about. there's language in there that says in unrelated conduct, he was accused of recruiting people. Is that going to count for a role offense?
You have to access, your classification manual is 5100.8. It looks intimidating, it's a manual, but when we used to train the case managers, it's not that difficult. You get the worksheet up on the DOP website, the manual in your lap, and the appendix at the end defines what the roles are. You have to compare the verbiage of the pre-sentence to, it has major roles, it has minor roles. It has, was I a financer and paying for the airplanes for this large cartel? I mean, it methodically defines roles of minor conduct and major conduct. Nothing to do with role enactments or adjustments or anything like that. So you really just have to apply the verbiage of the pre-sentence to what the manual says is a great severity offense.
And one other question, how often, if the case manager requests a waiver, a public safety factor waiver, how often is that ever?
You want to take that one down? She's recently retired.
I
don't mind answering.
If that waiver is approved at the institution level and sent to Grand Prairie, that's whether it's a transfer or just, the warden approves it, that's it. As long as the case management unit team supported, typically that's something that's approved.
Okay,
But it's still a spinal decision by Grand Prairie, who has all these other impacts. Like I'll use the example lately. Since the Bureau of Prisons closed the alien contracts for the non-citizens, for the ICE people, there's a lot of low security people that came back in medium security facilities right now, and the agency has assigned a population management variable to those people just because of population. So I'm seeing case managers and wardens signing off on transfers to get people back to their low security facilities, and Grand Prairie denying them for population management. So, every case specific.
got it, okay.
All right, who else has got questions for us? Shoot.
With 8 points for being under 24, my first question is under 24 at the time of the offense or under 24 at the time of
The designation.
the designation?
Yeah, that's something to be conscious of.
It makes sense to age the case a little. Do you have a 22?
No, you're making good points. It's just here's what it is. Be aware of these things because, just say they process the designation today and tomorrow there's a birthday. Well, that's when I started talking about what's the practicality of having the judge say, and you're being aware that Your Honor, my client is turning, 25 tomorrow or something, or 25 in 6 months from now. Could be 9 months from now, and that's all I remember. The next increment down is 2 points. It's not like if he's over 24, he's getting 0 points. It goes 8, and then it goes down to 6, he loses 2 points. And so it's important in the whole overall scheme. So if that is a significant factor, you want to make sure that would be a appropriate recommendation to recommend the lesser security battery.
And my other question, and I guess Mr. GIBSON, an offender is a member of one of those gangs, and they debrief with DOP and ask to drop out of the gang. Does that mean they still have to go to one of those facilities forever? Or does it mean that you still open up to them and they can go to other facilities with more programming?
You can see there's a slide I have for that. I skipped over it because we're short of time. If an inmate does go through the debrief process, the debrief process includes his requested to drop out of the gang, and he does an autobiography, he identifies everything about that gang he can. When during the debrief, sometimes the National Gang Unit will be there. National Gang Unit also invites FBI and other law enforcement. During that process, he has to be 100% honest. If there's any time that he's dishonest, they're down and he's back on regular yard. If he goes through the process, he'll get an STG, a security secretary assignment, and a gang job. And he'll go to one of these jobs listed there. If he still scores as a penitentiary inmate, only because of points, he'll go to either Tucson, Coleman, or Carolina. If he scores as a medium, goes to the medium security job yards. So there's specific yards for inmates who are dropping out of gangs, only because of security threat and the social security.
I need to make a quick point on this, and Donna, maybe you can talk a little bit about backstanding versus drop, and you hear this terminology thrown around. I don't know if anybody's ever heard of a backstanding yard or a drop yard, but there's no real policy on this whole draft process. They came up with the pilot. Don was in the pilot back in 2011. A subsequent policy never really came out. So the point I want to make now is most everything we're talking about is policy driven. It's cut and dry. This gang issues are very, very tricky because of the lack of policy, as well as it's fluid. I mean, you mentioned the MS-13 syringe thing. Like, this could change 3 months from now, so let's explain that, like the fluidity of gang yards and things like that.
So, what was more confusing with the gang stuff is the MS-13s used to be subservient to the maximum off MS-RANs. However, in January of 2022, MS-13s asked for a bigger seat at the table, and they forced themselves to put a bigger seat at the table by killing a bunch of stringers in the civilian bone. The Bureau was completely surprised by it. They had no advance warning up. They didn't even have any idea. And so we did a nationwide lockdown to kind of sort through it. Based on the animosity now between the MS-13s and maximum off MS-RANs, MS-13s now have their own designated yards. Those are Yazoo, Mississippi, Beckley, West Virginia. Most security facilities now live in Stuco, Pennsylvania. So if they're an MS-13, those are the 4 yards to go to, only because of the bars that happened at Bowman back in January 22.
When the DOP did their training in Los Angeles in August, they basically want to know generally where the threat is. They really don't want you picking gang yards, non-gang yards. The DOP needs to know what the specific threat is to that person, the gang affiliations. They strip down inmates and they take pictures of tattoos, they put it on a national gang database and things like that, just to be aware of that. So the agency will get to the bottom of it to some degree.
Actually, I think he just answered my question. I was curious how BOP actually determines gang membership and whether there is a difference between membership and affiliation. How useful is the PSR in that process, or is that a separate determination that BOP does?
So the National Gang Unit will have a point classification separate from what we talked about today. And there'll be a points for owning it themselves, admission. They get points for tattoos, they get points for paperwork they have. They may have some gang memorabilia, they may have some diaries or some gang rules within their paperwork. All that stuff adds up to points, and I create points a lot. I apologize. But based on that, that may be enough to make them a member of an organization. To get a drop, you actually have to be a member to drop the organization. You can't drop if you're not a member of an organization. So you may have guys that are associates or suspects that you don't have enough points to actually make them a member. I guess that's very nuanced.
Can we talk about specific enemy concerns, so not a gang, but a client who, has a drug debt, someone they know to be in a federal institution, and it doesn't come up in the PSR because it's not related, but they have some people they'd rather not see in their institution. What's the best way to get that information to be able to be considered as their designation?
In a case like that, it's not as a separate team. So it would be separated from other inmates. We can separate inmates from other inmates. It's a very simple computer system they have. It tracks the whole thing of where all the separate fees are. That way, that those inmates will never go to those facilities where the separate fees are. But the Bureau has to be aware of it. So,
The question is, how do the Bureau aware?
So I would say between the defense attorney and the prosecutor, get the information to the Bureau that we need to federal threat between these 2 inmates, and we're requesting. U.S. attorneys request separation all the time, and then we load it in based on the attorney's request. So if you can get that done, separation goes in, and they never get into it.
Is there any prosecutors in the crowd? This is important when we're kind of retrial. I'm glad you brought that question up, because many times during the prosecution, the BOP has threat assess and collusion separation assignments. So many times prosecutors will do a collusion memo. We don't want these people getting together to compare stories. And that gets put in the marshal's database when we talk about that USN 129 form before. Well, somebody's got to go and undo that. And everybody ends up pleading guilty, and there's no animosity, there's no cooperation. That's in the database. Often we see that not get erased. And when that doesn't get erased, people start on the larger cases, especially, people start getting designated farther and farther and farther away from home. And so we as case managers had to notify people of separate fees, not who, just that they had them. And so many times, and Don, I'm sure it's still going on, somebody surrenders or gets transferred, and you say, we have to keep you separated from one or more people, and they go, what do you mean? No, you don't. And then we come to find out from the prosecutor, oh yeah, that was back in pretrial status. The damage is done. People start getting designated farther and farther and farther away, especially in big cases.
So what do we do about that? How do we find out about that? How do we fix it?
Make sure that, be proactive about it best you can, depending on your relationship with the prosecutor. You want to make sure there is no collusion memorandum that they send to the marshals during pretrial during pretrial that got in the computer. They should be honest with you. I would imagine that there is or there isn't, and if there is, they need to undo it if there's no longer a threat. That's the thing. We always had to reach out to the prosecutor because we couldn't remove it as an agency because we had the initial memo, but now we need that same prosecutor. And sometimes inmates who really there's a threat bother like the families account the prosecutor or the attorneys, and sometimes they just want to go away, so they'll say, oh, there's no longer a need. Sometimes we would not remove the separation because if that person comes to the prison and he gets identified or labeled as a rat, we had to be very conscious of what the initial threat was and why that initial threat is no longer valid.
Okay, I know there were questions, but it is 6:30, so these folks should